Interrogatories. Interrogatories are written questions sent by one party in a lawsuit to another, and those questions are to be answered by that receiving party under oath, in writing, typically within 30 days of receiving them. Now, when do we use interrogatories as a discovery device? We use them prior. Best way to use them is using them prior to the use of any other discovery device, such as a deposition, request for production. Actually, frequently requests for production and interrogatories may be sent at the same time. But they are used, interrogatories are used to gather preliminary information at the beginning of the lawsuit. The scope of inquiry for discovery and for interrogatories is quite broad. It basically can reach any matter that is not privileged and that is relevant. And another way to put it is that as long as it is reasonably calculated to lead to admissible evidence, well, then you can ask about it in interrogatories or generally any other type of discovery. Now, how many of these questions or interrogatories can you ask? Well, it depends on the jurisdiction that you're in. Typically, it's 25 or 30 questions. In some jurisdictions, like in Texas, certain types of lawsuits may limit you to even maybe just as few as 15 questions. And another thing is that you don't have to use all of your allotted interrogatories all at the same time. You don't have to send them all in one set. In fact, I always like holding a few back so that if further down the line I need to follow up with something or explore something new, I've always got a few interrogatories left that I can send. Now, there are advantages and disadvantages to all discovery tools, whether they be interrogatories, depositions, requests for admissions, requests for production. All of these have advantages and disadvantages. They're all to be looked at as different types of discovery tools. Just like you don't build a house or construct a building using just one tool, well, we use a variety of tools in constructing or building our case in a lawsuit. So what are our advantages of interrogatories? Well, I think first and foremost is they're relatively low cost. It's just the cost of time in the law firm of preparing those interrogatories, the questions, and sending them out. And many law firms will have standard interrogatories that they send out in every type of every type of a case that they have. Like if it's a family law practice, a lawyer may have a set of standardized interrogatories they send out on regarding property matters, or perhaps even custody matters if that's an issue. And it's very simple to just send out a set of questions to the other side. There's no court reporter involved, there's no filing fees involved, there's no record fees involved to pull those questions together and send them out. So it's relatively low-cost discovery. And another advantage is the responding party. When responding party gets those questions, they have the duty to seek out the information. Now, it doesn't mean they have to produce all the questions. There's going to be some objections that we're going to look at here in a bit, but they do have a duty, at least on the surface, to seek out this information. Now, there are certain disadvantages, though, to using interrogatories as well. One big disadvantage is, well, the answers that you get back are not going to be spontaneous. It's not like doing a deposition where the lawyer, a deposition on oral question where the lawyers can look the deponent, the witness, in the eye and ask them a question and get an answer right back and then have a chance to immediately follow up. The answers we get in interrogatories are not spontaneous. In fact, they've got 30 days to figure out how to answer or not answer your question without getting in trouble. More about that later. They're not a good tool for learning the nitty-gritty details of an inquiry. Deposition would be ideal for that, where you can have this back and forth and more spontaneous answering and questioning and follow-up. And as I said before, you can't easily follow up with interrogatory. Yeah, you can send another set of interrogatories, but this tool, interrogatories, is not readily suitable for that type of inquiry here. And then, of course, you have a limited number depending on the rules in your particular jurisdiction. So, what do we find in the interrogatories themselves, in a set of interrogatories? Well, first of all, there'll be some sort of introductory paragraph that is saying that these are interrogatories being sent by one party to another party or through that second party's attorney. And once again, interrogatories are only sent by a party to another party. You can't send interrogatories to a non-party. You want their information, you take their deposition. So interrogatories are from party to party, and in that introductory paragraph, you're identifying who's sending, who's receiving. There may be some instructions in that paragraph as well, saying that reminding that recipient that they've got 30 days or whatever time period is set out to answer those interrogatories. There will frequently be definitions that are given in this set of interrogatories. It's very important to make sure that if we're asking a question, that question is understood the way we are meant it to be understood. So if we refer to documents, well, what's a document? You better define the term document. If I say identify all persons who live in your household, well, what does it mean to say when I say identify? Typically, identify will mean give their full name, address, phone number, and maybe some other identifying information, perhaps like date of birth or something like that. But we will use that word, define that word, identify. You or your. We frequently will use that in that word or either of those words in a interrogatory question. So it's important that we define what you means. A not so humorous story for one particular lawyer that I know of. He was fortunately it wasn't my friend. My friend was responding to this set, but the lawyer on the other side sent a set of interrogatories. Please state your name. Did you have anything to do with such and such? So plenty of references to you and your, and then the definition defined you or your as being Mr. John Green or John Green's agents. Problem? My friend, the opposing side, wasn't representing a John Green. His name was like Bill Smith or something like that. And so my friend was basically said, we don't know who you're talking about. And he was just following the definitions. Yeah, he was being a little bit of a jerk about it, but that's why you have to be so very, very careful about using another form or another document from another case and then marking it up. You have to be so very, very careful when you do things like that. Questions. The heart of the interrogatories will be the questions themselves. And we'll look at how we draft those and some examples in just a minute. Then the attorney who's sending the interrogatories will be signing these interrogatories and then attaching, depending on the rules of your particular jurisdiction, but usually a certification or what we call a certificate of service certifying that these were sent by a particular method of transmission to all parties involved. So what are we going to ask? We're going to ask for personal information, or if it's a company, the corporate information, such as what? If it's a person, personal information, an individual, their name, address, phone number, job history, maybe even other recent addresses they've lived at. Maybe people who live in their household, that might be relevant in a particular case. We're going to ask same sort of thing on witnesses that the other party knows about. We want to identify these witnesses so we can depose them, so we can talk to them, we can interview them. We're going to ask the other party, what's your version of the facts? We may inquire, depending on the type of case, their medical history. If it's a personal injury case, we will want to know about their injuries that they allege that they suffered, or their diagnosis, or the prognosis, or treatments, or the doctors that have treated them, or hospitals, or locations, addresses for those medical providers. We'll want to know what their damages are. How much have they spent on doctor bills so far? Are they disabled or allege they're disabled in some way? We need to ask that information. Examples. Please state this is just an example of how we might do it. Please state the driver's license number and restriction and issuing state for any driver's license that may have ever been issued to you. Okay, just a straightforward question. Or state in detail how the accident occurred. You may even say, including the direction the vehicles were going, the time, the location, and so forth. So those would be examples of how we of what we might be asking. Drafting tips. We need to plan. We need to plan what we're going to ask depending on the type of lawsuit that we're dealing with. We want to ask, does this question lead to admissible evidence? If it doesn't, then we may not be able to use the answer. Well, in fact, if it doesn't, why are we even asking the question? Our questions need to be concise. They need to be simple. We want to avoid sub-questions like, please state, and then sub A, such and such, sub B, such and such, sub C, such and such. If you're not careful, some courts will interpret those subparts as individual questions and will count against your allotted total. You have to be very careful about that. We want to reduce lengthy phrases to just a class or a word. We want to be very mindful of the tense that we use in a question. Remembering one former president's famous response in a deposition, well, it all depends on what the definition of is. So we have to be very, very careful the way we word things. We want to ask questions in an interrogatory in such a way that we understand, is the person answering of personal knowledge or just what perhaps they've been told. Very important. We want to avoid asking a question that all we get is either a yes or a no. We want to get as much information for each question we ask as possible. And I always like to look at questions like this. Evaluate each question. Can I answer that question, what's being asked, in such a way as to not give the other side anything that's going to be useful? Can I answer it with a non-answer and still answer the question? If you do that, well, then it's not a very well written interrogatory. And then, of course, as I've said before, we want to proofread. We want to proofread very carefully what we're sending to the other side, paying special attention to the questions we ask and the definitions and all of that. And then the interrogatories that are going to be answered. The other side has 30 days to answer them. Those interrogatories, typically, there may be some exceptions to that, depending on when and how they're served. The other side, the responding side, can object by saying, well, it's privileged, you're asking for privileged information, I don't have to give it to you. Or it's not relevant, or what you've asked is overly broad, or it has undue burden on me to find out this information that you could perhaps find out better on your own. The information is not readily available, or I don't understand what you're saying. You're not being specific enough about what it is you want. Those are all typical objections here. We want to get assistance from our client for answering interrogatories. So when we receive interrogatories from the other side, we want to involve our client right away and get them working on that. And then when it's all completed, then we need our client to come in and sign their answers and swear to those answers. And that's an overview of interrogatories.